Hello, everyone. Sorry I had to miss this week's class. Personal intro. I'm going to record this lecture. So this lecture is going to be on the Judicial Branch, and we're going to look at the selection of judges, judicial structures between court, appellate court, and a district court. And finally, going to look at the judicial decision-making process, see how judges are divided and how they are making some important landmark decisions. So I'm going to start sharing my screen so you might not see me throughout the lecture. All right, so the PowerPoint has already been published on the Georgia View, and there's some voice narratives and some embedded videos you can watch. Here, just to give you a very brief overview of what's on this PowerPoint. So as we all learned, the judicial branch is an important part of the American political system. It is defined in the Article 3 of U.S. Constitution. But Article 3 left much of the details of this branch in very brief and vague manners. So a lot of things such as judicial qualifications are not clearly defined. And Congress and the president later had to construct the judicial system in this country by creating various courts, such as appellate court, district court, and special legislative court. So we're going to go over some of them later on. So first of all, let's look at the judicial selection process. So I have just go through the whole judicial nomination and confirmation process in the U.S. Senate, and President Biden just nominated Judge Jackson to be the newest justice in the Supreme Court. So she will be the first African-American woman served in the highest court. And so right now, the court has a 6-3 balance in terms of conservative justice and liberal justices. By adding Judge Jackson to the Supreme Court, will not change the balance of power. So the conservative still hold 6 positions on the bench. So that tells you that future decisions of the court will continue to be leaning in favor of the conservative judicial philosophies. So among the 9 justices we have on the court, we have 1 Chief Justice and 8 Associate Justices. So all of them have to be appointed by the President and confirmed by Senate. So you don't get promoted from Associate Justice to a Chief Justice. It's a separate nomination process. As I mentioned before, the number 9 is an odd number, but it's not something defined in the Constitution. At one time, we had 6, and another time we had 12 justices on the bench. So in the future, if the president wants, and he can increase or decrease the size of the Supreme Court. So we also mentioned previously in the current judicial system, when we not only just have one Supreme Court, we also have a system of court system, such as the constitutional court and the legislative court. So altogether, we have about 870 plus justices or judges serving on different branches. And most of them are protected by Article 3, meaning they all serve for life, and they are protected. And that there are some judges who are serving on the specialized court. Those courts are not protected by Article 3, but instead they are protected by Article 1, meaning that judges on the specialized court are not serving for life. They serve a fixed term of office. So they're less secure than the judges and justices who are serving on the Article 3 court or constitutional court. Again, we'll talk about that definition a little bit later. So this is the picture of the 9 justices we had. Again, this is not a current picture, and with Justice Stephen Breyer retirement, we just added the Judge Judge Jackson to the bench. So now we have 4 women on the Supreme Court, so which is a phenomenon. So from this lineup, you do see there are a great amount of diversity going on in the court. So we have 2 African Americans, 4 women, and there is 1 Latino. I think that this is representing some kind of progress. Of course, you know, if you look at history, most of the time the court are purely white males. So now this has changed quite a bit. So the judicial branch as a whole, you know, they are not elected, and they serve for life. So the public cannot hold those people accountable directly in any way. So this is all intended to ensure judicial independence. So judges and justices don't have to seek public approval in deciding cases. They basically guard the Constitution. Their decision, whether are popular or unpopular, is not the concern for them. So for them to guard the true meaning of the Constitution is their #1 job. So the ability of the court to review laws passed by Congress, decisions made by the president, or even, you know, ordinance and regulations issued by government agencies, school board of superintendents, all of those decisions can subject to what we call judicial review. So judicial review is a power of the court to examine the legality or constitutionality of any given public decisions. And if the court finds those decisions to be in violation of the Constitution, and then they can strike down. So this is called judicial review. It's very unique powers. You don't see that in practice in most of other judicial branches in other countries. So United States judicial branch is really a very powerful institution. It can strike down the decision made by other branches of the government. And also unique is this power of judicial review was not directly mentioned in the Article 3 of the Constitution. Instead, the judicial review was established through a earlier Supreme Court decision, which is called Marbury versus Madison. Again, this is a long story. You can watch the video that embedded in the PowerPoint. So in this decision, decided by court in 1803, the Supreme Court decided that the Judiciary Act of 1791 was part of the law was unconstitutional because it gives the judicial branch too much power. So by exercising this power by declaring a portion of the law to be unconstitutional, the court actually created a precedent of exercising this power. So this practice was never challenged by President or Congress. So this has become accepted principle. And so the court has continued to use this power to periodically to make rules on the constitutionality of certain decisions or laws made by President or Congress. But fortunately, the Supreme Court has exercised a lot of restraint on that. They don't just randomly declare law to be unconstitutional, and they probably overall have done something like a couple hundred times. Really not that often, given the sheer size of the laws that has been adopted by various governments. And another restriction is that the court is not reaching out to examine every piece of a new legislation and to decide if those new laws are constitutional or not. Instead, and they take a passive view, which is they wait only if a decision or law that was challenged by somebody, or in other words, has already caused harm, the legal definition of harm, and then they file a lawsuit with the Federal District Court, Court of Appeals, so on and so forth. Only the pending lawsuit will give the court an opportunity to review the legality of a law. So even when the new law passed, maybe judges have their personal opinion on that, but they don't do the judicial review, and they have to wait when somebody challenged this new law in the federal court. Okay, so that's why judicial review is important, but it's not that mandatory. We don't require every piece of law to be reviewed by the court. And judges and justices, even they wish, they can reaching out to examine the laws and the regulation on a day-to-day basis and trying to declare them to be preemptively unlawful. So this is something that limits what the court can do. But anyway, judicial review is a unique power the court has, and so we might give attention to that. So you should know many of those landmark decisions mentioned in this chapter and other chapters, and you may not know all the details, but at least you know what are issues were debated in the case and what are the court rulings on those cases. So the judicial selection process is a highly political process, as we can see from the recent judicial nominations, where the Republican president always trying to choose a rather conservative nominees, and where the Democrat president will always want to choose a more liberal justices nominees. But again, here the words of conservative or liberal is not defined in our traditional partisan sense. It is defined by the judicial philosophies or judicial doctrines those judges and justices might share. So we'll look at that judicial philosophy a little bit later. So so the process has been highly political. The president and Congress has fought many battles in the Senate. If the Senate was controlled by a different political party, you can expect the confirmation process will not be a smooth one. Okay, so this time the Judge Jackson had an easy time to get confirmed. That's because the Democrat Party controls both House and the Senate, and plus the White House. So it's not that much difficult this time. Now, with regarding to the nomination confirmation of local judges, because the judges serving on appellate courts or district court also have to be nominated by the president. So there is a practice which is called senatorial courtesy, in which the president will defer the decision whom to be nominated, and instead the president will let the senators who is coming from the state where there is a vacancy occur in the federal district court. And by doing so, the senators will normally concur with whatever their colleagues might choose for their own state. So this is a courtesy granted by the president through delegation of nomination power to the senators, whose district has openings. But if the senators are, like right now, President Biden is a Democrat. If somewhere there's a vacancy happened in the district court in a state, if the senators in that state is a Republican, can be sure the President Biden will not offer senatorial courtesy, will not yield that nomination decision to those two senators from that state. So the use of senatorial courtesy is conditional. Based upon the partisanship. Okay. Again, I will skip some of the videos since we don't want to record the video to be too long. As you can see from this slide, each president actually have a lot of chances to appoint a huge number of judicial appointees. As I mentioned before, there are 870 plus of them. But again, any given time, there could be dozens of vacancies anywhere in the country. So you can see the record. During the Clinton's era, he served as 8 years president. He basically select 306 district court judges and 62 judges serving for the Court of Appeals and 2 serving for the Supreme Court. So you can see that the public only become aware of the Supreme Court nomination process. But as a matter of fact, the nomination of appellate court judges and the district court judges are a routine task of the president and the Senate as judiciary committees. So that number shows you the number of people that has to be periodically nominated. All right, let's move on to the second part on the structure and the power of the federal court. So this diagram shows clearly the basic structures of the federal court. The federal Supreme Court is the highest court of the United States. It has jurisdiction over all courts in the United States, regardless it is a federal court or state court. So a lot of state courts will end up, a lot of cases from the state court will end up in the Supreme Court. But in this diagram, it shows there are 2 kinds of court. So the Supreme Court, the Court of Appeals, and the U.S. District Court. Those 3 are called constitutional court. And sometimes they are also referred to as the Article 3 court. So there are 12 regional-based Court of Appeals and 1 U.S. Court of Appeals for the federal circuit. So there are altogether 13 federal Court of Appeals. And then in each state, there are at least one federal district court. So altogether, there are 94 federal district court. In Georgia, we have 3 federal district court. So, depending on what kind of law you are dealing with, if you violate the federal law, you go to federal district court. If you're violating the state court, you go to state court. Okay, so state court are another ball games, another different systems. Each state has a separate judicial system. So we have 50 sets of state court. And this is not showing on this diagram. Now, the bottom boxes here is another different type of federal court. And those courts, such as military court, Court of Veterans Appeals, tax court, those are the special tribunals or specialized court that created by Congress under the jurisdiction given to them in Article 1. So they are also called the legislative court or Article 1 court. As I mentioned before, the judges sitting on those courts has a fixed term office, and they don't serve for life. Okay, so they're less protected than the judges who sit on the constitutional court. Okay, but their numbers not that great. Most of the judges sitting on the constitutional court. Right, so to understand this differentiation, the division of the different court, you have to understand the two concepts here. One is called original jurisdiction, another one is called appellate jurisdiction. So whenever you start a litigation or lawsuit, you don't go to Supreme Court. You start with the federal district court, okay? Because the federal district court exercise the original jurisdiction. So the responsibility of the federal district court is serving as a trial court. And they have a right to hear the cases and establish evidence and facts and to reach verdict. So all the dirty works are done at the federal district court level. So that's why you're here watching TV, you see all the people testify before the court. You have two parties and lawyers and attorneys, kind of cross-examine witnesses. You can display of evidences and bloody and knives and gloves, and that's where you see all the real business going on in the courtroom. Now, the appellate court, they are the one really dealing with the decision already reached at the lower court, at the federal district court. So their responsibility is to examine the decision of the lower court, and their main concern is not about to repeat what you have seen in the district court, like testimony, cross-examination, display of evidence, establishing fact. That has already been done. So the main difference between the appellate court and original federal district trial court is that the appellate court focuses primarily on procedural issues, whether or not the plaintiff or defendant had a fair trial, or whether or not their the due process of law was violated if they given a chance to prepare for their cases. So a case can be thrown out of court simply because of legality issues, because of the procedural violation. And also happen in this level of court is that the court can examine the application of the law in a particular case. Maybe judges use the wrong law. Maybe the law itself is questionable. So that's where the judicial review will take place. If the law is okay, but somehow the judges find, oh, there's something happening in the law that is clearly in violation of the Constitution, and that's where they're going to use judicial review and to declare those laws to be unconstitutional. So judicial review does not always happen at the federal Supreme Court. It can happen at the Appellate Court, even sometimes, and in the District Court. Okay, so original jurisdiction and appellate jurisdiction are used to basically to set up those two features. So on this diagram again, you notice that the District Court is the court that exercises original jurisdictions, and they are the trial court, where the Court of Appeals and the Supreme Court, they are strictly appellate court. So they only review the decision already made by the lower court. Well, having said that, there's one thing I want to point out, because the United States Supreme Court can also serve as a trial court, can also exercise original jurisdiction. So how that is possible? So whenever there is a case involving a government, either a state government or federal government, president or Congress, so those entities are considered to be sovereign entities. And sovereign entity typically have the immunity, so that you cannot sue those sovereign entities unless those sovereign entity agree to be sued. But sometimes, the sovereign entity can sue another sovereign entity. For example, you can have a state government suing federal government suing a state government, or state government suing another state government. So whenever a case has a sovereign entity involved, and those cases fall under the Supreme Court jurisdiction. So you don't start your cases in the Federal District Court. Instead, they file the case directly with Supreme Court. So every year, probably the Supreme Court handles about 5% of those kind of cases directly, without going through all those District Court and Court of Appeals, because those cases handling a sovereign cases. All right, so this is a kind of a summary, shows about which cases will file under original jurisdictions. So any cases involving foreign diplomats, involving a state, or between the state and the state, those cases will under the original jurisdiction of the Supreme Court. And the next slide, and again, is a total illustration of the court structures. You can see this a little bit more in details than the one we used previously. So all the boxes that are in the yellow colors, those are the federal constitutional court, Article 3 court. All the boxes are in the blue colors. They are the legislative court or the special courts, where all the boxes marked in green colors, those are the state court. So again, there are 50 sets of those boxes, and every state has its own Supreme Court, have a state appellate court and a state trial court. So, but again, all cases can reach to the Supreme Court, and Supreme Court can review all decisions made. So that makes the Supreme Court the highest court of the United States. Again, this map shows the boundary lines of various federal courts. The colors indicate the Federal Court of Appeals boundary lines. As you can see, Georgia's, Florida, and Alabama, we belong to the 11th Court of Appeals. Sometimes we also call the Circuit Court, where you can see the entire west coast of the United States, and also including Alaska and Hawaii, all belong to the 9th Court of Appeals. And now if you look more carefully within each state, you see some state have those, broken dots and broken lines. So where some other state, it doesn't have any. So in Georgia, because of our number of population, number of cases, so Georgia is divided into 3 federal district courts. You can see it in the Texas, it has more than 3 district courts. But then if you look at Montana, Wyoming, they don't have those dotted lines in between, but also because we guarantee every state has 1 federal district court. That means the whole district court boundary line is the same as the state boundary lines. Okay, so this gives you a real knowledge about how to find those court. Now, caseload. You know, American is a country of lawyers, and American is a country of laws. So there's a lot of litigation going on every year. But most cases are pretty much, I guess, state cases. So you can see here, state trial court handles over 9 million cases a year. But again, this data are outdated. Probably right now, you can see the number could be even greater. And most of those cases will travel within the state boundary lines, going through the trial process, appellate court reviews, and state Supreme Court reviews. But some of the cases did end up in the Supreme Court. Okay, and so the federal Supreme Court is the last stop of all cases. Even though your state Supreme Court might decide, hey, you're going to be executed, but you can still appeal your cases to the federal Supreme Court. Now, the federal district court, again, handle all the cases dealing with federal laws, but not all cases dealing with federal laws are handled by federal district court. Okay, I guess that there's a limited resources and manpowers with federal court. So any cases like civil cases, if involving a claim that's smaller than $60,000, $70,000, and those cases most likely will still be heard by the state court. So the state court has some responsibility to handle some of the lawsuits involving federal laws. So that reduces the federal burden quite a bit. But still, on this map shows that federal district court still handling or hearing over 300,000 cases a year. Now, some of the cases and people are not happy with the decision, they will file an appeal with the Court of Appeals. You can see that over 40,000 cases will seek appeal to the Court of Appeals, and then eventually 65 of those cases decided by federal Court of Appeals will seek further reviews through the Supreme Court. So there are a lot of cases coming from this route. So altogether, each year, the federal Supreme Court will receive something like 8,000 or even 9,000 cases, petition the Supreme Court for review. But here is the differences. For other Court of Appeals and Federal District Court, those hearings, those reviews are generally mandatory. If somebody file a lawsuit, then you have to hear it if they meet all the criteria, right? You cannot just say, hey, I don't hear it. No, if they meet the standard, you have to hear it. So the review of those decisions are mandatory. But the Supreme Court reviews of all the petitions is non-discretionary. It's a discretionary, non-mandatory. So it's a discretionary, meaning that the court decide which case they want here and which case they don't want here. And so over 95% of the cases will be rejected by Supreme Court. So currently, the Supreme Court hear about 70, 80 cases a year, okay? And so they don't handle that many cases. And the reason for that is because, again, there are only 9 people, and They don't have enough manpower to handle all cases. And it used to be they had to deal with all appeals, hear all the cases filed with Supreme Court. But until early 20th century, and Supreme Court finally had enough, and they drafted the bill. Later was passed by the Congress that they changed the mandatory review to a discretionary review. So that served to reduce the caseload for Supreme Court. Now, by only hear a limited number of cases each year, it does not suggest the Supreme Court is not active or is lazy anyway. Many of those cases that reach to the Supreme Court are involving large legal issues, and so the court only interested in listing some of the cases that have not previously decided, or the cases are worth reviewing. There's a lot of discussion going on. But anyway, so that gives you the ideas of how cases were handled by the court. Right now, let's talk about some of the landmark decisions made by the court. So the court history roughly can be divided into 3 period of time. From 1789 all the way to 1865, Civil War. And the court was filled with all the cases dealing with nation building, dealing with the legitimacy of a federal power, state rights issues, slavery issues. So the court made a lot of important decisions about those issues. So the cases about McCulloch versus Maryland, Dred Scott versus Sanford, those decisions, dealing with the national supremacy, dealing with the state slavery issues. So again, we don't have time to look into details of the cases. So I hope you will take some time to do a little bit simple search to look at those cases and why they are important. And in the second period of time, after the Civil War, before Great Depression, even including early part of the Great Depression, we see that the new issues was mostly about the economic rights, property rights, and the role of federal government. Okay. So that the reason for that is because the United States has gone through a relatively stable period of time. We're going through economic taking off. So there's a lot of economic legislations, economic dispute surfaced during that time. And also there's some civil rights cases dealing with the discrimination against African Americans also surfaced during that time. So you will find many landmark decisions was made during that time. One of the cases I mentioned here is the Plessy versus Ferguson case. So in this case, some of the civil rights organizations trying to challenge the Jim Crow laws or segregation laws made by Louisiana state. But unfortunately, the court struck down that litigation, the root, and separate can be equal. So the doctrine of separate can be equal was used to justify the continued use of a segregation system in all states. So only till 50 years later, in Brown was a Board of Education decision, finally the court overturned the separate but equal doctrine, rewrite the Plessy decisions. So between the 1937 all the way to present, we can see court was busy and dealing with a lot of issues about the due process of law, political liberty, racial equality, social equality, gender equality, all of those things. And also issue about the gay rights, abortions. So the cases that I list here you see the Brown was the Board of Education, was about the desegregation of a public school system. The map was Ohio, Miranda was Arizona. All those are dealing with the rights of the suspect. You know, what kind of rights that they have. They have the right to have lawyers. And what about the Fourth Amendment search and seizures? And what about the Miranda rights? And so does the suspect have to consent to search? And does the police have to read the suspect, detainees, their right about their right to remain silent, so on and so forth. Again, we don't have much time to look into details, so I really hope you will quickly search for those cases and to understand the significance of those cases. All right, so let's look at the last question, which is trying to understand the judicial decision-making process. Let's say now you're in the Supreme Court, the highest court, and you try so hard to have your case going through all the trial court decisions and appellate court decisions, and finally you reach the Supreme Court. So how does the Supreme Court decide which case to be selected, to be heard? And when they do hear the cases, how do they, on what basis do they make their decisions? So that's the key we're going to look at. That is trying to understand the judicial making process. So all judicial decision making are taking place in this room, the judicial conference room, where you see that just there have just 9 chairs. So when they meet on every Friday here, you only see the 9 justices will be sitting here. And in this conference meeting, they will decide which of the new cases they want to hear about it, and what are their individual decisions on the cases they already heard. And that's where the decision will be made in this room. You know, if you have 5 people agree on the one side of the argument or decisions, 4 people against it, and then you have a majority. Okay, so you don't have to have unanimous consent to make a decision. So when you secure 5 judges to decide on a position, and that decision will become the opinion of the court. Opinion of the court. So opinion of court is also called the majority opinion. So each justice will be given some assignment to write their majority opinions or minority opinions. So in any typical court rulings issued to the public, you will see a majority opinion, which is how the court decided on those cases. Could be 5 people, could be 6 people, it can't be unanimous. You will also see the dissenting opinions, which is opinion of the minorities. So even they lose the case, and the justice still want to write their individual opinions and to state how they differ from the majorities and on what grounds. So those are both important part of judicial decisions, and history will serve to test who is right. We know a lot of decisions made previously with majority rule, but later turned out they're wrong, and the minority opinion actually is correct. So yeah, that's why important to include the dissenting opinion in the court ruling as well. And sometimes in the court ruling, you also hear 2 other kinds of opinions. One is called the plurality opinions, And another time you hear another opinion is called concurring opinions. So concurring opinion are the opinion written by the justices who are on the majority side. So they agree with majority opinion, but they might have a different logic, different reasonings. And so the justice decide I have to make clear my positions. So they might write a short, brief summary. So how he differ with others, even though they all agree with the conclusions. So that's what a concurring opinion is all about. Well, the plurality opinion does happen. And so when the court has no clear majority, and so they're divided. So let's say they're divided, one side has 4 people, another side has 3 people, another side has 2 or 3 people, right? So no majority. So what can you do about that? So the court basically decides to ask each side to write their separate opinions. And they put all the 3 opinions together and issue them to the public. So there's no decisive ruling on those cases, and they only reflect the division of the court. Yeah, so those are the 4 type of opinions that you will see when you read a case. So the majority opinion is opinion of the court. The minority opinion is the dissenting opinion. They are important supplement to the majority opinions. And the concurring opinions are the opinions from the justice on the majority side, and trying to explain their way of thinking. And plurality, meaning the court is divided, right? So that's, you understand what's going on in this courtroom, okay? So those 9 people, they are working as a lonely thinkers. They don't really collaborate or consult with one another. But they all read their individual briefs, and they working with their staff and legal interns. They develop their own opinions. So when it comes to that meeting places, they simply read their own personal opinions to that. And they might try to lobby one another to change each other's opinion. That happens. And sometimes the 1 or 2 justices might decide to give up their own position to join the other side. And that's possible. Okay. But prior to that, there's very little discussion or collaborations. So they are quite independent on how to reach their decisions. Now, let's go back to the other side. How does the court decide to accept the cases? So every week, the court receives a huge number of petitions. So if you divided the 7,000, 8,000 cases, you can see how many cases the court will receive during that 40, 50 weeks of sessions. The question that we ask is why there's not that many cases reach the Supreme Court. Out of millions and millions of cases that court tried at different level, but only several thousand reach the Supreme Court, and there's a reason for that. And one is called deterrence. So because the plaintiff and all the litigants knows involves a lot of money to file all the way to Supreme Court. So sometimes people just reach just basically accept whatever's been decided, and sometimes they go with the plea bargains and just trying to saving monies. And the fact of fee shifting can also add to the cost. If you have cases where the plaintiff, which started a case, if he or she lose, and then other side might ask him or her to pay all their legal costs. This is called fee shifting. So the high cost and high rejection rates and serve as the most important deterrents. That's why we don't have that many cases. And second, there's for a case to be accepted, it has to meet certain criteria. The legal term for that is called standing. For a case to be accepted, you must have a standing. And standing including a number of things. First, the case has to be real case, real controversy. There has to be real injuries. And it has to be brought up to the court by a real person. The actual party has to show up. So you cannot have a hypothetical case. You cannot have a friendly case. You just want to see how the court going to make decisions on that situation. The court has no time to waste on those hypothetical situations. And lastly, the sovereign immunity we just mentioned. If say somebody's son was killed in the war the president started, you cannot really sue the president because the president is a sovereign head of state and he make that decision on behalf of the nation. So he has a sovereign immunity. So you cannot sue the president for the decision he made. You can sue the president as an individual. If the president committed something like a personal wrongdoing, yes, you can sue the president, but not until he stepped down as the president. So as long as he is a president, he still enjoys sovereign immunity. Okay. So that sovereign immunity is a very important principle. And finally, sometimes individual, you might have a case, but sometimes it's pretty difficult to pay for legal cost. And so sometimes people might rally their cases together to start a class action lawsuit. So class action lawsuit always being brought on behalf of all people in the same situation. We see more and more of those kind of cases in the court. All right, so let's say the Supreme Court has received your appeals. The basic rule of thumb for accepting your case is called rule of 4, meaning for the court to hear your cases in the Supreme Court, all you need is to have 4 people to consent to accept your cases. Sound easy? Well, it is not. So, to have 9 people to agree on anything is kind of difficult. To have 4 people agree on anything, even that's difficult. Okay, so that's why rejection is so high, because even have 4 people is hard to get it. You don't have to have majority, but even 4 people is difficult. So let's say if you're lucky one and your cases was decided to be on the court calendar, and the court will issue a right of certiorari to the lower court to ask them to send all the legal briefing, legal document to the Supreme Court. So when you receive a right of certiorari, means, oh, good luck, your case is accepted. And the next thing will be the oral argument, where the plaintiffs and the defendant will show up in the Supreme Court. You have the lawyers have a chance to argue for their case. This is called oral argument, and typically only have 1 hour for each case, and each side probably only have a half an hour for the lawyer to talk. So you sometimes you hear the cases being discussed, being heard by the court, but you don't see any live feed and the live video recording of the events, and that is because the Supreme Court has maintained this long historical tradition that they do not like cameras in the courtroom. So you probably never see a updated pictures and where the court in session. There are only 1 or 2 black-white photos was taken inside the court, taken by somebody illegally, and there are a couple of black and white photos circulating on the net. You can still find them, but you don't have any color pictures of the court in session. And we still do not have live coverage of Supreme Court in sessions. So only progress we have so far is the court has agreed to set up the audio recording system inside the courtroom. So you can hear the live argument sessions, and those recordings will be made available on the Supreme Court website. You can hear what each party are saying through those video recording. So that's only progress has been made. Now, there's a terminology here mentioned called Amicus Qre. So Amicus Qre was a legal brief that the court asked the public to submit it to the court. So the time when the court inviting public comments is when they are dealing with some of the tough issues where they need some help. They are generalists. They may not have enough knowledge about some of the special cases dealing with stem cell research, narcotic drug laws. So that they might send the invitation to the public saying anybody who are interested in viewing your opinions, you can send a Amicus Qre to the court. So Amicus Qre literally means the opinion of the friends of the court. Okay, so that's really the only opportunity the public has to influence the judicial decision-making process. So a lot of people, a lot of groups take this kind of an open door policy very seriously. They will spend lots of money to write those legal opinions, and court will have a chance to read them. Of course, you're going to have those briefs submitted by both sides, either pros and cons. And ultimately, it is still the judges who have to make up their decisions and based on the merits of those legal documents. All right, so we already talked about the judicial conferences, talk about those 4 types of opinions. So the next slides summarize the flow chart of the case, how they travel. Again, here you can see start from beginning. You have the cases that file from this federal court or state court, and once they go through the district court trial, the appellate court trial, or in the state level, either they go through all 3 levels, either trial court, appellate court, or state Supreme Court, and then they can request for Supreme Court review after going through all those processes. And then the justices will meet in that conference room every Friday, and they will discuss the merits of those cases. And if 4 people agree to accept the cases, and the case will be put on their docket and be scheduled for a oral argument. But again, here you can see 98% of those cases will be denied. So when a case denied, basically just the lower court ruling will stand. So the court's not interested in interfere with the decision that already been decided. So after that, the court issue of right of certiorari to local court, and then each party will be sending their legal briefs and document support to the court, and each justice will receive 1 complete set and to review them, to read them. So prior to their sitting in the courtroom, they had already know the case pretty well. They read it pretty much everything. So this really, the oral argument was not really a design for the justice trying to go over everything over again. So most of the time, if you hear those audio recordings, it's simply the in exchanges or conversations between the justices and the lawyers on each side. So the oral argument really gives the individual justices an opportunity to ask more questions, to clarify the reasoning, evidence used in the case, So it's not guarantee everybody the lawyer will have 30 minutes time to keep talking. Okay, and a lot of time could be simply two judges keeping arguing with one another. Okay. So again, once the oral argument was heard, they will go back to the conference meeting in that week, and they will have discussions and vote. And then if there are 5 people agree on one positions, and that's where the court has reached an opinion on this case. Simple. But they will not issue those decisions right away, because it takes a lot of time to write a perfect opinions. So the Supreme Court Chief Justice will assign people from each side to write a opinion on behalf of that group. One people from the majority side will be chosen to write the majority opinion, and then other people dissenting, they can write their individual dissenting opinions all together as a group. And that will take some time to write, and sometimes could be just a few paragraphs, sometimes could be 40, 60 pages long. And once those documents been written, they will be circulated among all justices, and justices will make a comment, and changes be made. And finally, when ready, they will typically the decision will be issued at the end of each session of the court. And the court will start each session in October each year and last to May or June next year. So that's the time the court in session. So when they hear cases, might be in early October, but you won't be able to read their legal rulings until May or June. That's where all the finished legal opinion will be issued to the public, and where you're going to see a lot of media coverage or discussions on various cases that decided by the court. Okay, so that's the whole process. And then last issues we want to look at is the judicial philosophies. You probably hear that a lot during the Judge Jackson's hearings. So in terms of law, Americans tend to follow 2 traditions. One is called the Roman law tradition, and another one is called the common law tradition. So the Roman law, of course, is derived from the ancient Roman empires. It stands that the judges do not make laws. Their job is to apply laws that have been made by other authorities. So when there's no laws, there's been no rulings be made. Okay, so judges should not make laws. That's the strictly Roman law tradition. Where the American, they're a former colony of British, so the British common law tradition had much impact on American legal system. So in Great Britain, they are based on common laws. The judges had made historically thousands rulings, and those rulings had become part of a British common laws. And so judges says what it is. So whatever been decided by judges will be used as the basis for future decisions. So when there's no law, and judges can still make a rulings based on their own understandings, on precedents, on customs, legal training, and their own wisdoms. So based on those 2 legal traditions, American has developed 2 judicial doctrines. One is called the strict constructionism, another one is called the judicial activism. So strict constructionism is a view that believes the judges should defer policy making to President and Congress, and the judges should not make public policies, and they should not apply their personal policy preferences in their legal rulings. So whenever there's any doubt on the meaning of the Constitution or any particular laws, The judge's responsibility is to go back to read the legal documents from that time and the laws made, and to discover the original intent of the Constitution of that laws. Okay, so it's not about what the judges believe should be. It should be what the writers of the Constitution really meant that to be. Okay, so this is also called the strict reconstructionist. And the judicial activism is based on the common law tradition, and they give the judges a lot more responsibilities. And they believe the judges should be involved in public policy making and should be involved in resolving political conflicts of the time they live. So when there's no laws, the judges can still make decisions and to make a rulings trying to achieve certain desirable social goals, such as the Brown versus the Board of Education cases. So in that case, the Supreme Court not only struck down the separate but equal doctrine, but also they declared the segregated public school system should be totally abolished, and all public schools must be integrated. So from there, that's where the school desegregation started. So the court was so serious about the issue, they ruled twice on the same case, Brown 1 and Brown 2. And so Brown 1 only declared the segregated public school system violating the 14th Amendment Equal Treatment Clause, and separate cannot be equal. But then they only asked the state to integrate the public school system. But later, when they found out there are public resistance on the court decisions, and court issued a second ruling, 1 year after, in Brown 2, the court asked all state government to implement school integration with a deliberate speed. You cannot postpone this whole desegregation by smear techniques, by postponing it. So you must do that with a deliberate speed. If you need 5 years, and they want to see the plan how to get it done in 5 years. So the court actually want to monitor the whole process. So the court was heavily involved in the school desegregation process. So the Brown cases serve as a good example to see how judicial activism works. Of course, now we kind of appreciate it with that court active involvement, that the segregated public school system have become a history. But if you go with a more justice who are believing the judicial restraint, the strict constructionist tradition, and they're probably going to say that, well, even though the segregated public school system was questionable, but the court should not be the one to terminate it. It should be the responsibility of the president and the Congress, because the judge is just not in a position to make a new education policies. Okay, here, so that's where how you should understand what we mean by calling some justice being conservative and some justice being liberal. So the liberals are the one who generally share the activist views and give the judges more role to play in public policy making, where the conservative judges are the one who trying to restrict the judges' roles in policy making, and they don't believe the judges should make new public policies. Okay, hope this brief recorded video help you, and hopefully I'll see you soon back in classroom. All right, bye-bye.